Welcome to the Heart of Law podcast. My name is Mirena Umizaj, and I'm your host. I started this podcast during COVID to stay close to my community of friends and colleagues, but also to raise awareness to the deeply important causes this community pursues with passion and persistence and vision. On this podcast, I have invited some of the most successful and interesting people I have met in my 10 years of being in business. Today is no different, and in many ways better, because instead of one guest, I've invited two. They are David Selby and Todd Mathews, partners with Bailey Glasser, a very well-established firm that consistently leads efforts on some of the largest mass action cases in U.S. history. David and Todd are incredibly talented and accomplished trial lawyers, very well regarded by the legal community, who recently tried the bankruptcy trial against Johnson & Johnson, which we will go into more details later. Gentlemen, welcome to the Heart of Law podcast. It's been a long time coming.
Thank you.
Thanks for having us, Mirena. We appreciate the opportunity to talk about this important issue.
There's a lot I want to cover here today with you, and a lot has happened in the past 2 years for our industry, some good and some not so good. The two of you haven't skipped a beat despite the many challenges you faced. And before we get into it, I want the audience to learn a little bit more about who you are. So Todd, you are a master of all trades. Can you expand a little bit more on your background and the kinds of cases you've been involved in over the years?
Sure. So 30 years ago, I had this crazy idea that I might want to be a lawyer. And that road has been long and winding, as they often are. I've covered everything from a simple divorce, adoption, car wreck case, speeding ticket, adversarial IRS tax liens. But for the last 15, 20 years, I've handled significant injury claims, whether that be trucking accident, train cases, but more importantly, more focused on asbestos litigation and pharmaceutical litigation. So some of the cases I've worked on are, the Actos litigation, Esure, Roundup. If you name it, I've probably worked on it in some way.
Yeah. Well, you're very well known, and everybody knows your name in this business, and that's because you are very well accomplished trial lawyer. And we don't have enough of those in this business. So it's good to have you as part of our community and the work you've done. So thank you for that. David, you too have an extensive background in law. What would you have a very extensive background. And so I didn't want to take too much time. We're going to link your bio here in the podcast. What would you say are some of the defining moments in your career or things that you've done in the past few decades?
So, I started out, it's interesting because I did not have a path coming out of law school like where I am now. That was never in my vision, never a thought process of, hey, I want to be doing mass torts or I want to be doing even plaintiff work. Coming out of law school, I went immediately to the district attorney's office. I was in the district attorney's office for several years. I was very fortunate. Nothing I did, it was just fortuitous circumstances that allowed me to get into a situation where almost immediately I was thrown into jury trials. And so I went from, doing jury trials, quite a few of them from the start. And then I went from that to, again, because of just circumstances that were present, to being able to be a division chief of the violent crime division. And it allowed me a very deep immersion very quickly into people, into dealing with other counsel and dealing with a variety of different judges, law enforcement, victims' families, gave me I feel like a very unique perspective into the whole jury system, even albeit criminal. So that made me realize then that I I like the side of the jury trials. I came out of law school with a little bit of thought that, hey, I might want to do corporate work. And then I realized that was not me at all. And so I went from that. When I got I left the DA's office because of an opportunity of a firm that I'd clerked with that asked me to come back. And they primarily did defense work on the trial side, medical malpractice defense work. I did that for a number of years. Went from there to a firm, a bigger firm that similar to the firm I'm with now, in that we did a mix of plaintiff and defense work. I found myself there gravitating towards the plaintiff work. I'd not had much experience on that side, if you will. Did that, and I guess around 1999, myself and one of my other partners there, we started our own law firm, and it was two of us, and we grew that to about 12 lawyers at one point. And after doing that for about 10 years, I realized that I wanted to do more and more plaintiff work. We had basically a shop set up to do more of the insurance defense type work. Mm-hmm. And so I went out on my own. And while I was out on my own doing that work, I had just through some friendships and other things, some people at Bailey Glasser, and joined Bailey. They asked me to come on board, I guess, 12 years ago now. And so came on board. I think at the time I came on, we had 20 something lawyers. Mm-hmm. We're hitting right at 90 now. We had 5 offices at the time. We're over 12 offices now. So I've seen a tremendous growth. Our firm, it's interesting. People ask all the time, what's the reason for your growth and how's it planned? Use Todd as an example here. Our firm, and I was in the same situation Todd was, and that is the founders of the firm and the philosophy of the firm has always been, we don't have necessarily a defined growth pattern as much as when there are really talented lawyers that we know we want to be with and be doing work with, we go and get them. And so historically, that's the way we've operated. It hasn't always, been a set out, hey, we need to go find these 3 lawyers to fill these 3 positions for this specific area of our practice group. It's been, hey, Todd Mathews would be a tremendous asset to our firm. Yeah. Let's go get him.
So it's funny because that was going to be my next question, because I knew Todd before he joined Bailey Glasser, and I kind of saw the whole transition, and I knew the two of you were friends. And so I don't think I've asked this question. How did the two of you become friends, and how did that conversation start of Todd joining Bailey Glasser?
Yeah, so that we became friends through mutual work. We both, we had met each other before at some hearings and had mutual colleagues, mutual friends. But Todd and I both we were both on the executive committee with the Atrium MDL, hernia mesh MDL. And that's, I guess been 6 years now in the running, 5 years. And that was it, really. That was the first time we were able to truly work together on something. In the beginning, of course, that was a daily conversation in the throes of the litigation, working with each other. So, and we had other mutual friends within that litigation.
Right.
So that was it. It seems like we've been friends much longer than we have. But yeah.
That's awesome.
That's what started this great journey.
Yeah, no, I've seen it unfold, and it's quite special, because there's nothing better than being able to work with people you like and call friends, right? Work is hard enough as is. And if you're not with people that you enjoy being around, then, you know, what's the point of that? So I totally understand. Todd, what have been some defining moments in your career and life, would you say?
Well, that's how many hours do we have to talk about this?
Can go as long as you want.
You know, I guess there have been several that I look back on and think my life would have been completely different had this not occurred, right? And so growing up, I won't tell the sob story that, you hear from a lot of plaintiffs' lawyers about how they were dirt poor and blah, 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 blah. But, the way I grew up was very difficult in some emotional ways. And thankfully, early in my teen years, I found a family that really kind of took me in and introduced me to the local church. And that became a very important part of my life. And it absolutely has defined who I am. My path really in high school was I was going to be a Southern Baptist preacher. That's what I was going to be. Mm-hmm. And you could not have convinced me that I would have turned out to be anything other than that. And so through that, though, I developed a real passion for people and helping people. And that was really my focus and was always my focus was, here this family took me in. I want to be able to give back. I want to make a difference in people's lives. Yeah. And just through, life events, I ended up in law school. And when I got out of law school, it was, I've got to find a way to use this to benefit people. Yeah. And so I was fortunate enough to find some good firms over the years to where I could try cases. I could make a difference in people's lives. I had some, pretty remarkable cases that I was able to work on, cases I was able to settle. Probably 10, 12 years ago now, I had one of those career-defining moments where I represented these 3 kids whose mother had been hit and killed by a train. And it was a circumstance where the train company had showed up on site within 10 minutes of the accident, had found some witnesses to say that certain things had or had not happened, which ended up not being true at all. And so, through that litigation, we were able to put life-changing money into the hands of these 3 children that had lost their mother, had been, dirt poor, sleeping in the same clothes that they went to school in for weeks on end, that kind of lifestyle, to the last time I checked in on them, one of them has now graduated from college. The other 2 are flourishing where they're at. And so, that's not a case. We were able to resolve that case without trial. So it wasn't a huge media spectacle, but right. The way it changed those kids' lives was defining for me.
Right.
In being able to make that kind of change.
Right.
And so that, I always kind of hold that out as one of the moments. We've already touched on it, and he'll probably get frustrated with me saying it, but I honestly mark one of the life-changing moments of my life in meeting and developing this relationship with David. And I've said this privately, it's, the last 6 years of practicing law has been extremely enjoyable because I get to work with my best friend.
Right.
And so it's life-changing. It's defining. The way I do things is different now. The way I think about cases, the way I approach cases is different. And it's because of that relationship. So not to sound corny, but that is one of those moments.
Yeah.
And then probably the other life-changing moment, setting aside the kids that you have and the kind of personal things that go on in one's life. The other really defining moment was 2 years ago when my partner, Randy Gori, passed away. He, under very, very horrific circumstances, was murdered in his home. And he and I were very, very close friends. And so, it changed the way that I thought about life in a lot of ways. Yeah. And as we get older, we start thinking, well, maybe tomorrow isn't promised, but at 48 years old, you're not necessarily thinking that.
Yeah.
And so it really changed my perspective on, you need to be happy in life. You need to take time to enjoy things in life. You need to identify those people in your life that are really important and make sure that they know how important they are. Aside from my personal loss, which was one of the most significant things in my life, the legal community lost a great, great person. And I always described Randy as somebody, if you met him on the side of the street, you would think that he was maybe the postman, the guy that, manages the grocery store. You wouldn't think that he had this amazingly successful career, the top of the asbestos field. You would not believe that was the person you were talking to, because he was just a normal, down-to-earth kind of guy. And we don't have a lot of those guys in the legal profession, or gals. We just don't. We don't have that. And so the legal community as a whole lost a tremendous, tremendous amount through that event that took place. And a lot of that is how I ended up with David and Bailey Glasser. Is, I wanted to, if I had the opportunity, I wanted to work with my best friend. Why not? I don't know how much longer I've got on this earth, but I'm going to enjoy it while I'm here.
Yeah. Yeah. Which is exactly what we were talking about. Yeah. I'm deeply sorry for your loss. I remember I was in a conference hearing about Randy and read some of the details and was truly horrified how something like that could happen out of the blue to somebody that just is minding their own business. And he was just such an asset, like you said, to the community. So it feels like yesterday in many ways, but also with COVID and everything that happened after that, it's just been a weird couple of years, right? So I'm glad that you have sort of emerged, because that can, really hold somebody down, right? It's very heavy and it's very difficult to navigate out of something like that. And so to see you come on the other side and continue focusing on, family and career and doing really well, it's heartwarming for me. So.
Well, I appreciate that. And I mean, it truly is. We don't know what other folks are going through. And, my loss, while in my mind is a huge personal loss, the loss that his wife and children experienced, it's uncomprehendable. Yeah. And, a tragedy, and we never know what other tragedies people are going through. And so when I see this, the dark side of this business, if you will, of just the cutthroat, the mean-spiritedness, it always makes me stop and pause and say, I don't know what that person's going through, and they don't know what I'm going through.
Right.
And so, I think if you can use the motivation of these tragedies to do better, to be a better person, to make a better world, that's the way you can respect the loss in those tragedies.
Yeah.
And I think that's extremely, extremely important.
Yeah. Not to go too off topic, because we're currently witnessing a crazy war between Ukraine and Russia. And just to see the kind of turmoil over politics, over things that human lives should not be wasted on, is truly tragic, right? So there is tragedy, there is uncertainty in every area of life, and it's truly horrific. And it's, as parents, as professionals, when these tragedies happen, or when you see a war that's unfolding on the other side of the world, and me having been on that side of the world before and having witnessed some of that war firsthand, for example, you're not the same. And I think the spiritual strength that it takes to continue staying stable and focused, despite of all the noise, all of the things that's going on, that are going on around you. I mean, that is spiritual strength. And I regard people like that, people like you, with so much respect, because it's not an easy world to live in. There's just too much going on. So, but
Mirena, along that line, Todd and I have talked about this before, and as parent, and you and I have had this discussion with all that's going on in the world. It is so, for what we all do, I sometimes, we lose sight of the fact that what our struggles are, are nowhere compared to what other struggles are. And I try to emphasize this to my boys constantly, and that is, everybody you meet has a story. And yeah, there's good stories and there's bad stories, but everybody's life has a story. You don't know what it is. Be careful how quickly you judge people. Be careful how quickly you assume you know their story. But regardless of how well they appear to have things together, everybody has a story. And I try to talk to my staff about that and preach it to myself with my clients. When you get a client who's calling and is frustrated about whatever, whether it's lack of communication, whether it's the fact that, it's easy for us to chalk it up and say, for example, the reason your case hasn't reached trial is this thing called COVID. Well, that's easy for us to understand. And it's easy for us to know that the court system, for all its positives, there is a lot of problems that are inherent with the pandemic, with the court system, just like anything else. So when they do call frustrated, they do get upset with you. It's because of, you don't know what their story is. I mean, and people sometimes are, very living out their unfortunate story. And you happen to be maybe it's the word I'm looking for. You happen to be maybe the unfortunate receiving end of it because of what we do. And, because of what we do, we have people at their worst times.
Yeah.
So,
true.
I look at, Randy's situation and his family, as Todd pointed out, and then, what I saw Todd go through, right, because of what happened with Randy. I mean, that's unfortunately, part of his story, part of Todd's story, part of, his kids' stories that will be forever. So, I mean, it goes back though to what we do for a living, how we do normally have people, the situation we're dealing with is not ever their best situation.
Yeah. No, and I think, like I said, it's a testament to the strength that somebody has to really understand how to navigate, day to day, because you are inundated with negative news, with, details about a case that you don't really, that are not easy to stomach. So it's part of the everyday life. So to be able to rise above and still remain optimistic and do the right thing is truly respectable. So I'm curious to know, because, and we're going to be talking a lot about sort of the last trial that both of you were in, which I think it's a very important trial, and it's going to impact consumers and this industry in a major, significant way. But before we go to that, how has the practice and business of mass tort class action evolved over time? Because a lot has happened in the past 10 years, right? So in your perspective, Todd, what's changed, and how have things evolved? Good, bad, and everything in between.
Yeah, so things have definitely evolved in the last 10 years. I think, the first traditional mass tort case I filed was a Vioxx case. So that was, now going on close to 20 years ago.
Right.
But in the last 10 years, I've really seen a huge shift in a lot of ways. One great thing I've seen happen, and I say this and I continue to say this, and I'll continue to say this until I'm too old to remember what I'm talking about, is one of the best things that I've seen happen in the last 10 years is the focus that has been put on female attorneys, minority attorneys, getting opportunities to lead MDLs, to have a significant impact, to be elevated to judges, to be the judges that are handling these large MDL dockets. Even 10 years ago, which doesn't seem like that long ago, it was almost always a older white judge that got the case, older white men who were the leads, and middle-aged and younger white men who were the backup support for the lead counsel. If you go back and look at statistics, it's shocking. Just 10 years ago, that was the case.
Yeah.
And now we see, even with the most recent appointment, I believe, in the CPAP litigation, where the court has taken upon itself to put together almost an advisory group of young lawyers that the court has appointed, that assures that we're going to have people of various ages, various backgrounds, ethnicities, genders, rise up through the ranks and be able to handle this litigation with that experience. And so that, to me, and the reason I say I'll continue to preach it, I've got a 18-year-old daughter who's getting ready to go off to college. And I just think if she'd come up, 20 years ago, she wouldn't have had the opportunities she's going to have 10 years from now. Right. And it's because of this focus that's been there. So that's one of the huge differences I've seen.
Yeah.
Other differences, certainly the financing that has come into the space in the last even 5 years has changed things dramatically and will continue to change things dramatically. Where we may have had a case with 10,000 clients at one point, now there may be 50,000. And I could argue good and bad for both of those things.
Right.
So that has definitely changed the way cases are acquired, the way cases are worked up, the way cases are tried, the way cases are resolved. And so that has made a tremendous difference in the space.
Yeah.
And then I guess the third thing, which we're going to talk about here in a little while, is how this whole bankruptcy play is going to play out throughout the system. And that's something that's, immediately changing in the business.
As we speak. Yeah. David, what would you add or subtract to that?
Well, I agree with all that. Number one, I would say too, I think that one of the big differences that I've seen just even in the last 5 years, right, is the ability, and this is a good thing, the ability of firms through not only just through the use of, resources, if you will, but those resources transcend from, you think about a firm that has 4 or 5 lawyers and a staff of 3 people. Well, 10 years ago, with the lack of vendors who could handle your medical records, the lack of vendors who could handle your lead generation, who could handle your medical record review, who could handle your intake, who could fill out your plaintiff fact sheets. Those really didn't exist like they do today. So it does allow people to get into the space that otherwise couldn't have gotten into the space. And, I'm not of the belief ever that, there's this finite, source out there, if you will, and that everybody needs to worry about who gets in and who doesn't get in. I mean, if we all do what we want to do and do it well, work follows. And, Todd and I have the distinct, pleasure of, our founding partners and the people who remain and, so to speak, in control very much fall under the belief system of, good, clients follow good work. And that, that even goes from, the ability to say, look, we're going to try cases, win or lose, but when you're known as you'll do it and you'll do it well, good work follows. I think that is a trend that we're going to see in the change in the mass tort world, quite honestly, because I think one thing that has changed dramatically, we've seen this with 3M, we've seen it with, you start naming the mass torts, unfortunately, are maybe gone are the days of the fin global settlements where everybody files everything you can, they have in their inventory, and the day comes when, you wait for it all to resolve. It's I think the global settlements, are going to be fewer and fewer. And, it's going to be a situation where firms that have the threat of litigation on the plaintiff side have the threat to show the defendants, we've got enough trial lawyers to try as many cases as get picked for a bellwether. We're ready to go. That's going to become more and more the model for going forward, especially, as the defendants do get away from global resolutions and, reach individual settlements, if you will, inventory settlements. So I think that's that is a future that I do, a change I've seen and we will continue to see.
Do you think that that's a reflection of how sort of all of the things that Todd mentioned, the capital, the leadership, and the political dynamics, do you think that has impacted different business models? So you now have many different types of law firms that have emerged, right, in the past 10 years. You have the litigators, then you have the aggregators, then you have the advertisers, then you have a hybrid of all of the above. And so if there are no global settlements, if now you've got, a law firm that's really an aggregator law firm, right? What's the expression? Stack them deep and settle them cheap. You've got that model, and they go to the table with a bunch of cases versus a firm that has trial lawyers and has a track record of trying these cases, and they go to the table with certain cases. The demand is going to be very different. And so the defendant is going to treat them very differently. So I don't know if it's a question of, is it the chicken or the egg? But I think both sides have impacted the outcome that is unfolding today. What are your thoughts on that?
Well, I've got some rather strong thoughts on the issue. And so let me back up just a little bit. I said I could argue the good and bad for the funding that's coming into the space.
Right.
One of the things that I think is great about the funding that's coming into the space is it is allowing for a lot more clients to be reached, a lot more injured parties to be reached. And that is always my goal, is helping people. And so I think, if you've got a firm that has access to one amount of money, they can only reasonably handle a certain number of those clients in the right way with that limited amount of money. Mm-hmm. But if they've got additional resources, they can reach a lot more clients.
Right.
And handle them correctly, ethically, morally, and the right way. So that's one thought that I have. The other thought I have, to your point, is here's an ethical question I just kind of throw out to anyone listening. If you're, whatever you said, stack them deep and settle them cheap, if that's your philosophy,
right,
and let's just say you're able to get the clients $10,000. The firm that is willing to try the cases, that has the heavy hitters, that has the Brian Glassers that can go out and try the case and scare the defendants, or the defendants respect that trial lawyer enough to know that they're facing a real uphill battle. And that lawyer is able to get $50,000. Okay. If you're the one who's seldom cheap, have you disserviced your client by either not having the wherewithal and the desire to go try that case, or by referring those cases to somebody who can? Have you done a disservice to your client? And our number one most important goal should always be the client.
Yeah.
And if it's not, then I question your motivation in being a plaintiff's lawyer.
Yeah.
And I know that's kind of a harsh statement, but
no, I think it's a very fair statement, and I wholeheartedly agree with that. Yeah.
The client has to be the focus. There's no ifs, ands, or buts about it.
Yeah. So do you think, and I'm going to let you, David, answer this too, but do you think that that is a weakness that we are being attacked on currently by different defendants across the board?
We see that attack. We just saw that attack in the Johnson & Johnson bankruptcy trial.
Right.
A huge part of their traction that they got in that case was being able to point to attorney advertisers.
Yeah.
And saying, Judge, we need a bankruptcy, because if we don't have one, we're just going to continue, the attorneys are just going to continue to advertise. So it's absolutely front and center critique. Now, I don't think it's a fair critique. I think if you've got, for instance, a client who has used a product, has developed the injury that has causation linkage to it, that's not a frivolous lawsuit. That's somebody who needs to be compensated for the damage that a company did to them. But if we do it the wrong way, if we don't focus on the client and we focus on the dollars and cents of it, that traction will continue to be there for defendants.
Yeah. David?
Yes. So I do think it's an unfair critique of the industry, because, and we just saw this, as Todd pointed out, in the J&J trial. I mean, look, they went after personally, and without any conditions or reservations, if you will, took the position that, look, here, let's take the judge, these tout claims. They started out the first 2 years of the MDL, there were 2,000 cases. And then we can show where the spending on advertising, and they named the firms, right, in the trial. These firms spent this amount of money, and look what happens. The claims go up, enormously. So, judge, what they tried to, the picture they wanted the judge to think of is, this is all attorney driven and not client driven. They failed to point out to the court, and I don't know that the court ever appreciated this, but the fact that, that MDL, for example, in the ovarian cancer cases, one of the reasons the advertising shot up is because Johnson & Johnson was finally made to reveal documents that made everybody understand what they knew, when they knew, and what they hid. It doesn't take a rocket scientist to figure out that once that happens and you realize, man, these claims have serious merit. I mean, this just isn't, a few firms saying this is the theory. This is now their own documents, that we can use against them. So yes, let's go get these cases. And yes, women need to know about this. And how do they find out? But through the advertising. It's the hypocrisy of it in saying that it's lawyer driven and advertising driven and funding driven misses the whole point of no one's out there advertising for a space or a theory that doesn't exist.
Right.
I mean, these things come on their own, and they begin to develop as the case develops.
Yeah.
There's a reason the mass torts and the MDLs get bigger as they go along. It's because there's more
awareness,
bad shit discovered on these companies.
Yeah.
And so that's what happens. And they can couch it however they want, and they can try to, push it on us as lawyers and push it on advertisers and push it on funders. But the reality of it is it's their bad acts that lead to cases, period.
Right. So your law firm was recently co-lead counsel for mesothelioma creditor committee, and the two of you were part of a team that tried the Johnson & Johnson bankruptcy trial. I want to bring the audience up to speed because we have a variety of different people that watch and listen in, and we have a lot of young lawyers following. So, Todd, what are the talcum powder cases about, and why was there a bankruptcy trial against Johnson & Johnson? So I just want to sort of start and create a foundation.
Sure. So the allegations of talcum powder. So talcum powder, we're talking about baby powder. We're talking about what, everybody's parent in the United States used on them as a baby, but also that many women and men use as a hygiene product all over their body, usually right after they've taken a shower, for a variety of reasons, to control wetness, to control odor, to a variety of reasons. So this is a product that's been used for over 100 years. And from a company that has prided itself on being a baby product, being, America's product, everybody has it in their home. So the problem came about when Johnson & Johnson decided to test their product for asbestos in a way that would not reveal asbestos in the product. That's really what this case comes down to. So asbestos, as everybody knows, is a carcinogen. It's been designated as such since the mid-50s. And a lot of people know the history behind asbestos litigation.
Right.
This is a horrific mineral that comes out of the ground that has a fire retardant product to it, manner to it, so it was used in a ton of products. And then, lo and behold, it came about that it causes something called mesothelioma. It can also cause lung cancer. So that mineral, talc that's in the talcum powder, that mineral, according to geologists, cannot be mined without mining asbestos at the same time. The two coexist in nature. So you can't separate them. You can't go drill in this hole and get talc and go and drill in this hole and get asbestos. They're intertwined. So Johnson & Johnson, for years, tested their materials in a way that the easiest example, and I'll get it wrong, is, but Mark Lanier had a good example in his trial, where he took a very highly sensitive scale and put a needle on it, and it registered the weight of the needle. Then he took like a regular bathroom scale and put the needle on it. And of course, nothing's going to show. No needle's present because it doesn't weigh anything if you're looking at it on a bathroom scale. So the problem is the science says you only need one exposure to asbestos for you to be able to develop mesothelioma. That's it. And so for them testing in a way that they didn't have to report that there was asbestos in their product, they could say it was 100% asbestos free. That's really what this case is. Well, so as this case is developed, it became clear that asbestos can also lead to ovarian cancer. And so now you not only have the exposure that you would have using it as a hygiene product, but you also, when you're putting it on, when you're putting it on your baby, the dust, you're also inhaling. And so you have a mesothelioma problem, you have a lung cancer problem, arguably, and you have an ovarian cancer problem. So that's kind of how the litigation developed. As David pointed out, when this litigation started, there weren't a whole lot of cases. And then Johnson & Johnson was forced to disclose certain information through the discovery process. And it became apparent that this is what they were doing in the way they were testing this product. And so their product was not asbestos free. Numerous tests and studies were done where they went and grabbed bottles off the shelf and tested them, and there was asbestos in them. That's how the process came about. There have been numerous trials on the ovarian cancer side.
Right.
The most famous one being Mark Lanier's $4.2 billion case in St. Louis 4 years ago now. There have also been numerous mesothelioma verdicts over the years, on an average of about $36 million a piece. Some of them have been much lower, some of them have been much higher. So Johnson & Johnson, after numerous tactics, they tried to go through another bankruptcy trust, the Emerist Bankruptcy Trust. Emerist was their supplier of talc. They tried to get relief through that. They tried to get all of the experts thrown out in the MDL through a Dalbert challenge. They've tried appeal after appeal after appeal, some successful, some not. And so this became what they deemed internally as Project Plato, where the law firm of Jones Day went and pitched what we're going to refer to as the Texas two-step to Johnson & Johnson and said, you can take Johnson & Johnson Consumer Inc. They're the ones who hold the liabilities for the baby powder. Take JJCI, which is what we call it, go down to Texas, open the corporation there, do what's called a divisive merger. Out pops a company that holds the liabilities and one that holds the assets. Take your asset company back to New Jersey, where JJCI came from, and make it new JJCI. Take your company holding the liabilities and take it, we're going to rename it LTL for Legacy Talc Liability. We're going to take that, and we're going to put it in North Carolina in a favorable bankruptcy court, and we're going to bankrupt that company. And so all those liabilities are going to be held in LTL. And we're going to claim that we have to do this because the liabilities are so substantial that they make JJCI insolvent over if you take in current and future liabilities.
Right.
So that's how we ended up in the bankruptcy court. And then from the bankruptcy court, the judge in North Carolina correctly saw that this doesn't belong in North Carolina, it belongs in New Jersey. And so the case was transferred up to New Jersey. And then in New Jersey, the trustee split the case into two committees, one for ovarian cancer and one for mesothelioma. Because those processes, those arguments, the diseases themselves are pretty unique. And so the trustee thought that made the most sense. And so the motion to dismiss trial that was held in the middle of February was prosecuted by the Meso Committee and the Ovarian Cancer Committee.
Right.
And so that's how we've got to where we are today.
So David, what was your law firm's role in the J&J bankruptcy trial?
So our firm played a significant role. And that role, Bailey Glasser took a majority of the witnesses, Brian did the opening statement. I mean, truly Bailey Glasser was in this case because not only because of the bankruptcy folks we have on board, which, a lot of people may not realize this because they were who Todd and I are always around, and our colleagues. We're a mass tort firm. We do plaintiff litigation, but we also have a very robust and very capable bankruptcy group. And because of having the bankruptcy group tied with the high level litigation trial lawyers we have, like Bailey Glasser, it was just this beautiful combination that was needed for this case. So we were able to take the skill set of our bankruptcy, partners, meld that with the trial skills and the corporate structure knowledge that somebody like Brian had, and lead the charge in our attempts to get the case dismissed. And that was our role. Our role, up until, these roles change because the bankruptcy itself, takes different paths depending on where it ends up. But the goal from the very beginning by our firm was to not only get this case dismissed for a bad faith filing of bankruptcy, but to send the message to defendants and to law firms that make this advice to these defendants that you're not going to get away with this, and that this is a bad thing. That was our role, and that was our goal in it. A lot of people don't realize, the essential argument, J&J made for financial distress, if you will, despite their wealth, and despite the way they structured this, as Todd described. But their essential argument at trial for financial distress was how they were abused in the tort system, and how this lottery-like slot machine system that somehow multiplied the sum of all their litigation and tout fears. We took the position, at trial, that argument was just out of bounds. It was not only legally wrong, but just morally reprehensible.
Right.
The example we gave at trial, that Brian gave at trial, was just one example of, a plaintiff, Christine Doyle, and we pointed out to the court that, according to J&J, she got her ticket to the tort system because her husband died a horrible death, and so for Johnson & Johnson to call that type of loss a lottery ticket ought to offend every reasonable thinking person, conservative, liberal, undecided, right? This is not a issue that should be you take a side. This should be an issue where there is one side, and that side is, for J&J's disdain for the jury system is not evidence of financial distress, and that bankruptcy should not be a tool for these corporate defendants to decide we don't like the result we got, so let us run to bankruptcy. J&J wanted the bankruptcy court, to kind of justify the entire abandonment of what we all know as we sit here, everybody who will be listening to this, of our normal system of justice, just for the sake of efficiency and the sake of them saying that, well, wait, Judge, our fear of our liability is enough to allow this bankruptcy to go forward. And so, our role and our main focus throughout this thing, and will continue to be, and Todd and I and others at our firm will continue to preach this and preach this and preach this. And that is that at the end of the day, the jury trial system is the bedrock of our nation's justice system. If it yields judgments against plaintiffs, then we live with that system. That's part of it. And it does. And it has in these cases.
Right.
But if it yields results against the defendant, and it's because, jurors who are doing what they're supposed to do, and that's speaking the truth through a verdict, the result of that cannot be, well, we don't like it. We don't even like what the appeal court told us after we appealed the decision. So therefore, let us run and hide on behind the bankruptcy court.
So, honestly, I was watching this unfold and I was like, there's just no way, right? There's just no way that a court is going to allow a company like Johnson & Johnson to get away with bankruptcy. And you have 40,000 unresolved talc cases that need justice, right? And a big corporation like Johnson & Johnson decides that they don't want to be on the hook for causing people cancer. So like, it's a modern day travesty. I mean, I think it's borderline, or just criminal. It's criminal. And I can say that on the record, because that's how I feel. And it's a very dangerous rhetoric, but it gives permission to now all of these big companies that are negligent to basically do the same thing. And assuming that they're successful, because I know that there is one more step and that there is the appeal, but what does that mean for the consumer? I mean, can you expand on that?
Yeah. So, part of, you mentioned you got young lawyers on the calls usually, and, attorneys who don't deal with this every day, and perhaps some members of just the general public. So how we got here legally is, back in the 80s, when the asbestos liabilities became clear, Congress put into the Chapter 11 of the Bankruptcy Code, Section 524G, which is a device that allows companies, if you're worth $20 million and over the course of the next 30 years, you're going to have $30 million in liability. It was a system put in place that would ensure that some of the money that the company was worth would be set aside for victims of asbestos exposure. But it would allow the companies to continue on. So they didn't escape liability. They were forced to put significant assets aside to deal with those types of asbestos liabilities. It was a compromise, if you will, to make sure that rather than the company just going bankrupt, all of their commercial creditors getting paid and the injured parties getting nothing, that the injured parties would be compensated. So that was the purpose of it. Well, then in the late 80s, Texas implemented something called the divisive merger statute. And the purpose of that was really to allow companies a similar protection, not for them to hide behind their liabilities, but for them to be able to manage those liabilities in a way. Well, so during the course of this trial, some of the drafters of the Texas statute came out and they said, had we known in 1989 that provisions could be dubiously interpreted for entities to avoid known liabilities, such as those causing severe and permanent injuries, it would never have passed. This Texas two-step would never have passed. These are the folks, that's the intention of the statute. These are the people who drafted it. And they're saying these things. Another one, Curtis Huff, was on from the Texas bar. He's now with the Texas bar. He initially drafted the divisive merger amendment. And he said they had no intention that companies could hide behind the divisive merger statute. So we know that this is gamesmanship. This is nowhere we ever should have gotten to. But we are here now. Now, we are going to, appeals are being filed on this. That's going to be pursued. I feel very strongly about the appeal in this case. Okay. There is going to be, and already has been, legislative action being taken to correct this problem. So other companies can't do this. So it's important for everyone to understand that this is absolutely 100% manipulation of the system. This is using the loophole to its finest. Right. And that loophole, if we have anything to say about it, will be closed.
Right. David, what was the foundation for their legal defense? Was it that it just wasn't fair, that the system isn't fair to the company? I mean, I'd like to hear sort of the legal argument. I don't think I've heard that. If you can expand on it.
Yeah, I mean, so what you just said, what Todd had said, and what I mentioned earlier. I mean, they pushed very hard through the evidence of what they put before the court about what they're having to spend, the real defense, if you will, for their actions was the future liability that they face. And because of the future liability and the uncertainty, when you take those numbers and you extrapolate them using the numbers they used, that, hey, judge, look at all this liability we face. They had slides and presentations, no evidence, but argument that it's going to be in the trillions of dollars and that there will be cases for the next 60 years. So they used all the sum of their fears, if you will, is what they felt should drive the bankruptcy. Our position was, no, bankruptcy is not a menu choice, for one of the richest companies in the world to opt out of the jury system. I mean, they wanted the benefits of bankruptcy and then claimed literally in the same breath that look at the trillions of dollars of future claims we face. But then they, to this day and in the court, denied that there's any merit to the claims. There's no science. They don't agree with any of the science. They still deny their products ever contained asbestos. So it's a catch-22. If the claims are worthless and the science is worthless, then how can you say that, having as much as $60 billion in available funds through a funding agreement, that you're in financial distress?
Right.
And Mirena, I mean, it all comes down, in my mind, to smoke and mirrors. They want to say, well, we're going to face 100,000 cases in the future, and we're going to put this big number that has been awarded in a trial on every one of those cases, right? That's what they want to say. If they take the number, the true number, and even just put what we in the business would understand to be a really high settlement value, but a reasonably high settlement value on each case, you'd be at 25 or 30 billion dollars at the worst, and they've got $61 billion set aside for this. So there's no way they're in financial distress whenever maybe the liability adds up to half of what they got available to them for this case. Set aside the fact that a $450 billion company should not be able to file bankruptcy on a liability that may be 20 or 30 billion dollars.
Right.
It's ridiculous.
It's incomprehensible. So basically they're saying we're going to set aside $2 billion to resolve all the outstanding claims. Is that right? And then we just want to move on, basically. Right.
So there's a lot of detail to that analysis, but they began by putting aside $2 billion. They have a funding agreement that gets you up to the $61 billion is what they have. But their own counsel, their own internal in-house counsel has said he doesn't even think their liability is $2 billion. So if it's not even $2 billion and you've got $61 billion, you're not in financial distress.
Right. But that's the number that they want to use if they had to end all the current and future baby powder suits.
That's the initial number they've put on.
Yeah. So you go to the appeal. What happens if the appeal is not successful? What's the impact that it has on people, consumers, social justice, our industry? David?
Well, I think the kind of simple to the point answer would be what we all are worried about, right? And the fear of, who's next? What ABC company, is going to say, you know what? Why don't we do a divisive merger? Or you have companies setting out there, right as we speak right now, that the majority of the liability they may face may already be locked up in a subsidiary, of which they're just going to say, well, let's just bankrupt it. And we'll bankrupt it by shoving all the liabilities in it and, making it the assets depleted so that we show financial distress. And, what we've seen from this trial is come in and do the parade of horribles. Look at all these, feel sorry for us. We've got all this poor little company. We've got all this litigation we're facing, and it's never ending, Judge. I mean, it's a mountain we can't climb. We got to have your help. And as we have said before, the way with a literal stroke of a pen in creating a new company and creating this bankruptcy behind the desk of Jones Day, or name the law firm, you've now eviscerated everybody's right to a jury trial. And so I think the future is we're going to see more of it. We're going to see more attempts at it. I do think the positive of it, what I think it's gotten enough noise and enough attention in a good way. And hopefully things like this right here, what you're doing, which we so appreciate, will get the word out, and more people, Congress will act at some point. Don't know what that result will be, but as Todd pointed out, when you've got the drafters of the Texas statute saying this is not how it was intended, when you've got, most people have seen by now with the attention this has gotten, the letters from Congress, from Senator Durbin to Johnson & Johnson saying this is reprehensible. You need to answer for it. Unfortunately, I don't think the answer immediately is going to be a win in the bankruptcy court system for us right now. That's because of the result, we got with the order. But, maybe it did awake the sleeping giant, and people realize that, this cannot be right. I mean, this is not the way this was intended. The bankruptcy code, the bankruptcy system was never intended to protect the wealthiest company, one of the wealthiest companies in the entire world, for them to be able to shield their liability, their litigation for one specific thing. I mean, the other thing people sometimes don't grasp when we talk about the bankruptcy, a lot of people who are even familiar with bankruptcy think in terms of creditors. Okay, so the tout claimants are creditors. There may be other creditors of the company, the debtor that filed the bankruptcy, the LTL, right?
Right.
But there are no other creditors. I mean, they were able to shave off and say the only creditor is the tout claimants. So it's not even if you get past the quote financial distress argument, we're now talking something so new in the world of they have shaved off literally just their tout liability, and that's the only creditors. There's no other creditors, and the non-debtors, J&J, new JJCI, are sitting there with none of this liability.
Yeah. So this comes down to a judge, one person ruling that this is okay to happen, right? And
so far it has, right? Judge Kaplan has been able to issue the order, but then we're going to have it will progress up the stream. So the next stop may be the district court for them to review what happened. More likely, it'll be the appellate court, and then after the appellate court, we would end up at the Supreme Court. And I think that path is highly likely. At the same time, I believe there's going to be some other efforts to try and get to get it resolved. Certainly, look, if Johnson & Johnson would come in with their checkbook, they could end their spending of money on legal fees and trying cases.
Right.
They made a lot of progress with the argument that this is costing us so much money in fees and it's costing us so much money to try these cases. Well, the reason those cases are getting tried is because you're not settling the case. They control their destiny.
Yeah.
But so if they were to come in with a reasonable amount of money to resolve these cases, that could still be done, even while this bankruptcy plays out.
Was the judge's ruling well supported, in your opinion, by, why he decided to rule in their favor? Or was it just because on a technicality, the law allowed it, so he did? Because it's certainly not founded in any moral, foundation.
Well, look, Judge Kaplan spent a tremendous amount of time on this case. A 5-day motion to dismiss trial is unheard of. I've never heard of it.
Right.
He spent a tremendous amount of time, paid a tremendous amount of attention throughout the case, allowed the case to be put on, allowed for the information to be presented. The opinion was well thought out from his perspective. I happen to disagree with it, which isn't shocking to anyone. But I can't say that it wasn't well thought out.
Okay.
I think it misses some pretty important points. The primary one, taking away a citizen of this country's right to pursue their grievance against a viable company. That is a fundamental right that we have to a trial where our peers are going to sit and listen to the evidence and give us a ruling. And limiting that is, to me, the biggest miss in this opinion.
Yeah. Well, look, what you've done, what your firm has done is so appreciated and truly respected, because you did everything you could, and you're going to continue this fight, and we're all behind you and support you, and couldn't think of any better lawyers to do this. So I really hope it turns out for the better, especially for the clients, 40-some thousand clients out there that are still waiting on justice to be delivered to them, and really for the overall good of our society in this country. Aside from talks, I know we're running out of time, but aside from this litigation that's taken a lot of your time, what is in the works for you guys, and what's next? And is there exciting news?
Selby, why don't you go first?
David? Yeah.
Well, I was going to tell Todd to go first to talk about, a roundup project that he and I are both working on, but principally Todd is leading that, and some of the asbestos work. So I'll let him go into that. One thing I'll say kind of outside, I mentioned this earlier when I mentioned the bankruptcy part of our practice.
Yeah.
That even for myself, right, I'm not limited. Some of the other things I've got going on is I still have a very active defective firearms practice.
Right.
And that's something that our firm has really been a leader in across the country. We had one of the first, should I say, successful class actions against a firearm manufacturer for defective firearms.
I saw that, 239 million.
It was. That was the value placed on it by the court in Miami for the repairs and the shipment of the pistols, etc. It involved like 900,000 guns. That's still a very, robust part of kind of our contingent group, if you will. Most of mine and, almost a majority of my time, though, is now spent, on mass torts. But that's still a big part. We're very involved in 3M. We've got Kate Sharonko, Todd and I's law partner, is at the forefront in the ESI world. So she has taken a pretty substantial role in 3M in working on the ESI parts on that committee to get 3M cases. As most people listening to this will know, there's been a lot of those cases already tried. Our firm has several cases that have been selected to come up on the next wave of order for trial. So that's keeping us we're very involved in the 3M litigation. Todd and I both are involved in the Smith and Nephew hip implant litigation. That's certainly not one that's growing by plaintiff numbers. It's a pretty finite number, if you will, of people in that. Todd and I are both very involved. Is really going to be the next hernia mesh emerging litigation is the Covidian hernia mesh, which is pending in Boston. And not only Todd and I, but our law partner, John Roddy, is very involved out of our Boston office. John is leading the charge as liaison counsel for that. It's really kind of in its infancy, quite frank, even though it's been around a while. The litigation itself is in its infancy. And then I'll let Todd cover this part, but we've been very involved in the Bard hernia mesh litigation, the Atrium hernia mesh litigation, and somewhat the physio mesh litigation. I'll let Todd, he can kind of speak to where those are.
Yeah. So what we're working on, what we're getting ready to work on is all, really important to me, because it's a lot of what drove my decision as well to come join up with Bailey Glasser. There are few firms in the mass tort space that can take a case from inception, idea, to appeal if you need to, trial, right, and appeal.
Right.
And so, the prospect of having a firm that can do everything really well. I would put Brian Glasser's trial talents up against just about anybody. We have just hired Leslie Bruckner to do appellate work, who's been instrumental so far in the Roundup appellate work. And we're going to be continuing to work on the Roundup appellate work. I'm very excited about the Roundup cases still. I've been handling them now for 5 years at least. We're excited to try some of those cases once the Supreme Court decides what they're doing there. The other part of my main focus right now is on our asbestos practice. I was thinking about this the other day. I think I filed my very first asbestos case in 2005. So, and then of course I worked for the largest asbestos filer in the country for a number of years. And so I'm very excited. We've had an asbestos practice for a while. I'm very excited to help grow that practice. Those clients are near and dear to my heart because of how aggressive mesothelioma is as a disease. Right. I've sat in people's homes and watched them pass away. I've, been with their children at the graveside. They're very near and dear to my heart. And so I'm excited about that part of our practice. Yeah. And then, we are in the process of wrapping up the hernia mesh projects. Thankfully, COVID slowed those down substantially, but the three that David mentioned are in the settlement process now. And so I'm very excited that those clients are finally getting a resolution to their matters, because again, had COVID not happened, those cases would have been resolved 2 years ago. So, and then we've got some other exciting projects that we can't talk about, but we're excited about them. And we will be talking about them hopefully in the next few months.
Yeah. So do I.
There's one thing I want to say, and actually I want to read it. And
yeah,
if anybody's, sometimes my family ends up listening to the same things I listen to on podcasts. Yeah. So I want to say something to the families of trial lawyers, to folks who are out there doing what Selby and I do all the time. And I wrote this to my family the night before the J&J trial started. Okay. And it says, almost 30 years ago, I made a decision that whatever I did in life, I wanted people to say at the end of my life, I helped people. That I stood up for people who could not stand up for themselves, to use my ability to make the world a better place. I know that my being gone from home so much has been rough on all of you. For that, I'm sorry. Admittedly, not all the work I've done in my life will ever matter, will never be known nor appreciated. This work has provided us a nice life, given us advantages most do not have, and in general, other than the early years, has given us all so much more than most others will ever have. While I don't expect you to understand the magnitude of the J&J case, I want to thank all of you for letting me do this extremely important work. Almost 225 years ago, our country was founded on certain principles. One of those is the right to a jury of your peers. This right keeps the government and large corporations from being able to do whatever they want to average everyday citizens. It allows for a system that protects individuals and makes certain wrongdoers can be held responsible for their actions. Tomorrow morning, we will go to court and fight for this very right. What J&J has done threatens the very basic rights of our country. This is by far the most important case of my career, and more importantly, the most important case in our country since the cases that provided for equal rights for all people. It is only because of your support that I have the privilege to work on this case. Thank you for your sacrifice. I hope that one day, many years from now, you will all be able to say, my husband, my dad, stood up for what was right against one of the largest companies in the world, and in doing so, made the world a safer place. So to all the families, all the husbands, wives, children, parents, thank you for letting your family pursue these lofty goals of making the world a safer place. And that, as plaintiffs' lawyers, that's what we do every day. And Selby and I can't do it alone. One firm can't do it alone. It takes the entire system to hold these companies responsible for what they've done.
Yeah. I that's beautiful. And it pulls on my heartstrings because I am on the road a lot and I have 2 children, and my husband and I both own businesses. And so when he's out of town, I try to be in town, and vice versa. Right. And so it's so difficult and it takes a toll. And I don't do nearly the kind of travel that you all do and the work that you do out of town, out of county, out of state. And it takes a toll while you're pursuing a really, really important cause for the greater good. Your personal life is in the middle of that. And I think every lawyer that I speak to, that we have candid conversations and are strong enough to be vulnerable about their personal lives, will say that they're struggling with balance. They'll admit that they're not home enough, that they're not with their kids enough. And it's quite the sacrifice, the challenge. And I think having a supportive family, a family that sees what you're doing and supports it and understands it, I think there is no greater appreciation than that. And I know, Todd, you have a wonderful family. David, I've met your wife, and Rhonda, and she's a sweetheart and very supportive of you. And so, yeah, I think it's so very much needed to really say that on the record, Todd, to really thank the families for supporting people like you to do what you do. And I'm sure, David, if you wanted to share something along those lines too, you can.
I mean, I think Todd really nailed it. I mean, couldn't agree more. And, you know, kind of the for lack of a pejorative, I mean, the unsung heroes are our families, right? I mean, because I look at, you know, I was actually I count myself fortunate in a lot of ways in that kind of the brutality of travel and my travel schedule wasn't near what it is now when my kids were younger. So I traveled a lot, but nothing like I do now. My boys are grown and on their own, but I've got a very supportive family, extremely, in the sense of, you know, not only understanding, you know, what it requires to be on the road a lot and gone a lot, whether it's trials, whether it's depositions, whatever the case, meetings, whatever the case may be. And they get it, and that they understand why. And, you know, it would be pretty difficult if there was the lack of that support and that understanding. So,
yeah, agreed. Well, gentlemen,
and I will say the same about all of our law, you know, Todd and I's law partners, right, in our firm. I mean, you know, 110% behind everything we do.
Yeah. No, it's being in a big firm like yours is pretty unique, right? Because it's hard to keep a big firm like that together and a strong unit. And you all come across as a unit. And I think that's very unique to the firm, a testament to the core values that your firm holds, and just a tremendous asset to the business. So I have tremendous respect for all of you. So I appreciate the time. I know I've taken a lot of time from your busy schedules today. Honestly, I'm just honored to call you friends, and thank you for everything that you do. And we'll do this again.
Well, thank you. Really enjoyed it. Thanks for giving us the time.
Absolutely. Thank you so much.
My pleasure. Thank you.
Thank you.